1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်48ဦးမောင်မောင် and two others applicants versus မတ်တလုံးမှ respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Revision before ဦးသက်ဖေ Judge ဦးမောင်မောင် and two others applicants versus မတ်တလုံးမှ Respondent Civil Procedure Code Section 24 Transport of Suits and Execution Proceedings held the suit before the second judge is one for declaration that the court auction seal being null and void did not pass title to the respondent, whereas the proceedings against the applicants relate to the question of rent due by them as tenants of the respondent. The questions involved therein are not akin either in point of law or in point of fact. Three applications are therefore dismissed. ATKPL Mudia Chatti versus LAR Aruna Chalam Chatti 7 LBR 129 at 133 Maumo versus Pome 2 LBR 281 MAUNG versus MAUNG Lujo 1941 RLR 512 FB GM Rajulu versus M Govinda Nil AIR 1938 Madras 745 Varman Vasudo Chitalu versus Raghunath Ganesh Taka AIR 1949 Bombay 263 OS Mohiyuddin Sahib versus Yusuf Abdul Razouk 1951 BLR 24 XC Ahamud versus Kalu AIR 1915 Lower Burma 10 refer to Ukema 4 for the applicant Ubadan 1 for the respondent Utape Judge since this application and the revision applications numbered 52 and 53 of 1965 have been by consent had together. The present order will form the common order for all the applications. This application is filed by Umamang, while civil revision numbered 52 and 53 are initiated by Ujomyai and Uchimao respectively. They are admittedly tenants of the respondent, Mataloma, who had obtained rent decrees against all of them. She had taken out execution proceeding against them and had also sued Umamang and Ujomyai for further areas of rent before the learned third and fourth judges of the city civil court. It transpired that some six other persons instituted a suit against the respondent and two others before the learned second judge for declaration that they were the real owners of the premises which the present applicants are occupying as tenants, inasmuch as the court auction seal from which the respondent derived her title to the property was null and void. The applicants thereupon moved the landed chief judge, but without success, to transfer all the suit and execution proceeding pending against them from the files of the third and fourth judges to the file of the second judge. The power of transfer under Section 24 of the Civil Procedure Code is a discretionary one, which must of course be exercised under proper judicial principle. Occasion may arise where transfer may be justified on ground of convenience to the parties. ATKPL Mutia Chetty vs. LAR Arunachalam Chetty 1. No such ground of convenience to the parties or witnesses can exist in the present case, inasmuch as all the proceedings are pending in the same court, although they may be in the files of different judges. Transfer may sometimes be sanctioned when a litigant is under a reasonable apprehension that the trial judge has a pecuniary or other interest sufficient to create bias. MAUNG vs. p.48 2. There is no suggestion by the applicants of such an apprehension. Then the proceeding may rightly be transferred on ground of interest of justice if a party has obtained unfair advantage by the misuse of legal process in a particular court. MAUNG vs. MAUNG 3. The instant case is not one of this nature, or as the transfer may be necessary to avoid the possibility of conflicting decisions by two courts on the same question. G.M. Rajulu vs. M. Govindan nil. 4. Farman Vasudo Chitale vs. Raghunath Ganesh Taka 5N OS Mohiyuddin Sahib vs. Yusuf Abdul Razak Se. The suit before the learned second judge is one for declaration that the court auction seal, being null and void, did not pass title to the respondent, whereas the proceedings against the applicants relate to the question of rent due by them as tenants of the respondent. The questions involved therein are not akin either in point of law or in point of fact. Besides, it must be pointed out that the applicants as tenants are estopped under Section 116 of the Evidence Act from denying the title of the respondent, who is their landlady, and I fail to see how the question of title involved in the suit before the second judge can have any relevance to the proceeding pending against them. Furthermore, the applicants as tenants are under a statutory liability to pay the rent to the landlady in view of the provisions of Section 108(1) of the Transfer of Property Act, even though the lessor may have no title to the leased property. Ahamud vs. Kalu 7. For the aforesaid reason, the applications fail and are accordingly dismissed with cause. Advocate fee, Jet 34.